Welcome back, everybody. My name is Tom Olson. The name of the show is Olson on Law, every Saturday between 10 and 11 right here on News Radio WFLA. We're coming absolutely live today. My guest today is attorney Glen Wieland. Glen, welcome back to the show.
Thank you. It's good to be here.
Glen, I want to talk about car titles and the importance of how a vehicle is titled when there is an accident, and we can start with the basics, and that is that if you're driving a car and you hurt somebody and you're at fault and they're injured, they can sue both you, the driver, and the owners of the vehicle. And so if you're a married couple and it's owned by both of you and you're the husband and you have a terrible automobile accident, just by the fact that the vehicle is titled in you and your wife's name means that they could sue both you and your wife. Do I have that correct, Glen?
You absolutely have that correct.
So what is your recommendation to people when it comes to married couple or married couples that have, teenage kids driving vehicles in their homes? What's your recommendation to them?
Well, it all comes down to how much insurance do you have on the vehicle? How much are you at risk for collection of your assets? One thing I tell everybody is when your child turns 18, you need to give them the car that they're driving. Have their name as the only name on that title, because they may go away to college, they may be driving somewhere and they have an accident. No one can get to you at that point, because now they're the owner of the vehicle, they're the driver of the vehicle, and it protects you. The vehicle may still be insured, so your son or daughter still has coverage, but they can't get to the parents' assets.
Okay. Well, people ask me, that's a great advice, Glen. So we agree you got an 18-year-old, give them a beater car that they can bang up as much as they want to, put it in put the title solely in the name of that 18-year-old. Sometimes people ask me, Tom, well, just by the fact that the 18-year-old is living in our household, or what about this stacked insurance issue? Is there some way they can come back on me, the parent, because the child is living at our house, because we have some kind of stacked insurance?
No. If the title is just in the child's name and the child is just driving their car, the answer is no. But if the child's driving the parent's car, they take mom's car to go to the grocery store to pick up some things. Now you're back to the situation where that vehicle was titled in, the mother's name or the mother and father's name. Whoever is the title owner of the vehicle is what's called vicariously liable. They are responsible. The state looks at cars as what's called a dangerous instrumentality. They say it's like handing somebody a gun. Because one of the most dangerous things we all ever do in our life is drive a car. And so because it's a dangerous instrumentality, the owner of that vehicle is responsible to whoever they give permission and consent to drive the vehicle. If it's a stolen vehicle, there's no permission and consent. But whether it's stolen or not is a whole different issue. We've had cases where the keys were available to everybody, and you could just take the keys and go drive whatever car. They go, well, I told my son not to drive my car. But you made the keys perfectly accessible to him, and he's driven it many times before, so that's not really considered no permission and consent. So the parent is still vicariously liable. So you got to be very careful about who you give the keys to.
At Olson Law Group, we do estate planning for people. So as part of that estate planning, they often ask us about how to avoid liability. And I tell them a couple of things. One is that if you're a married couple, take the car that husband drives mostly and put it in the husband's name only. Take the car that the wife drives mostly, put it in her name only, so there's not this joint liability because both your names are on both their titles. The other thing I tell them is that if you agree with that, Glen?
That's excellent advice. And I think every situation's a little different. You want to make sure that whoever has the title of the vehicle, maybe they have their own business and they're the sole owner of that business. So you want to kind of that's why they need to come talk to somebody like you to say, how do we protect ourselves? from collections.
Well,
I'm sure you all do trusts for people for the same
well,
reason.
a trust is all about avoiding probate, Glenn. A trust has nothing to do with protecting assets from creditor claims. Glenn, other thing I tell people is that if you've accumulated wealth in your lifetime, and that's the clients we're seeing, they're 50s, 60s, they've worked hard all their life, they've accumulated wealth, maybe additional real estate, savings, IRAs. If you've accumulated wealth, your best defense is to be well insured, meaning you've got great insurance on your car and your home and your vehicles and your boat across the board, and you have an umbrella policy.
Absolutely. In Florida, when you and I first started practicing law, Tom, Florida required one type of insurance, and that was called no fault. Several years later, they instituted that you had to have no fault and you had to have property damage coverage, and that was because the banks had a very powerful lobbyist and wanted to make sure that their collateral was protected out on the roads. But the no-fault insurance, when you and I started practicing law 40-plus years ago, it was $10,000, which paid part of your medical bills and part of your lost wages. So 40-plus years later, it's still $10,000. And you and I both know, and your listeners know, how much medical costs have gone up, how much wages have gone up. And so $10,000, that's spent before you even get through the front doors of the emergency room.
Glenn, I want to cover one other issue. And some people have leased cars. Let's just say the husband has a leased car in the husband's name only. So we're not talking about car titles anymore. What happens if the wife is driving that leased car? What happens if one of their adult children is driving that leased car? The liability is when the title, everybody that's on the title is liable. What happens in a lease situation?
Well, a lease situation actually is essentially a transfer of the beneficial ownership of the vehicle technically. So the lease company is not responsible. The person that is the lessee of the vehicle is the one that's responsible. So and most lease companies require a certain amount of insurance coverage when you lease a vehicle to make sure that not only their collateral is protected, but that the driver and the owner or the lessee of the vehicle is insured to cover losses should they have one. So if you lease a vehicle through your company and you go home and your 16-year-old's driving the car and has an accident, they can't get to the leasing company, but they can get to whoever is the lessee of the vehicle.
Glenn, when a client comes to you and says, I was injured in an automobile accident and it was the other driver's fault, I'm sure one of the first things you want to figure out is what kind of insurance or policy limits does the at-fault driver have? How quickly can you figure that out?
We usually can get that information within a matter of days. Florida requires that insurance companies who insure people must produce the insurance information. And it's not just the insurance information on that particular driver. It's the insurance information on the driver, the owner. And then you have to ask the other questions that are very, very important. Like, was this person in the course and scope of their employment? Because now their employer and their insurance may be responsible. And you have to ask, are there any excess policies? For instance, some people have umbrella policies. What other policies might cover the vehicle? And that insurance agent and insurance adjuster has to give you all that information as well as the other driver.
Glenn,
and we have found cases where there was limited coverage on the vehicle, but yet the person was in the course and scope of their employment. So now we had a lot of collectability against the company and their policy.
Glenn, you have provided us with some great information today. Attorney Glen Wieland, my good friend and fellow lawyer here in Orlando. Glenn, tell the listeners again how they can reach you.
They can reach me at our law firm is Wieland and Delattre, Wieland and Delattre, DE, capital Lattre. The phone number there is 407-841-7699, and they can email me at Glen, Glen, at wdjustice.com. leased.com.
Glenn, thanks so much for being with us today, my friend. We'll see you again sometime soon.